topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Experts show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Orlando. Welcome to our 16th year of Ask the Experts, where we bring you the finest experts in the field of legal, health, financial, and home improvement. Hey, this is the last Thursday of the month. It's probably my easiest show to do because of you, the listeners and viewers. We get so many of your questions. I'm so glad. I guess I should feel blessed that you take the time to write out your questions, that you feel confident enough with our board certified. I still haven't gotten used to that board certified attorney, Alan Swartzide. Let me tell you something. We always have such a great time for the next 50 minutes. I have got so many questions from you about community association law. HOA, condo, and we love getting questions from board members, from residents. And I got to tell you, Alan is with one of the largest firms, K. Bender Rimbaum. I love doing this show with him. Good afternoon, Alan.
Hey, Steve. Thanks.
Hey, this is no suck up, bro. Your show is so easy to do. And what makes it so easy, besides everybody sending in questions, is the way you respond. People just trust you. I don't know why. No, people just trust you.
I think it's because I'm a lawyer that actually speaks English.
It could be. You don't talk over anybody's head, but first of all, because we are getting so many new listeners and viewers, tell people about K. Bender Rimbaum.
Sure. Well, thanks, Steve. Our firm is based in South Florida, but I manage the office here in Orlando. We've also got offices in Pompano Beach, which is the primary office, Palm Beach Gardens in Tampa. I manage the office that's actually in Winter Springs, but we say Orlando because people actually understand where that is. 25 attorneys now, 8 of whom are board certified specialists in this area of law, including me, 1 board certified in construction law. And listen, if you're happy with your attorney, good for you. I have no problem with that. But, if you're not getting the level of service or the level of knowledge that you'd like to see from your current association counsel, that's what we're here for. Start to finish, pretty much anything an association might need. And when I say association, I mean condos, HOAs, co-ops. We've got you covered. So, Steve, thanks for the opportunity to give a little intro, but I don't want to waste everyone's time that we could be answering questions with a little bio about me or the firm. So they're welcome to reach out or check out our website at kbrlegal.com if they want more.
I got one thing that I'm not going to call it waste anyone's time. We are so proud of you. You are board certified. And that is, what has it been now, 6 months? 5 months?
A little over a year.
Okay.
I think it was
Tell
summer
people
last
what
year.
that means.
So it essentially, without getting into details, and like Steve said, I don't really like to talk over anyone's head. It means that the Florida bar considers me an expert, and the other 7 people in the firm that have that same qualification, they're considered experts by the Florida bar as well. We have another gentleman down in Pompano who's considered an expert in construction law. This is regarding condo, HOA, and co-op.
So you had a lot of classes to attend to. And I got to tell you, if you look at people who practice community association law versus the ones that are board certified, God, you are in an elite group, bro. I got to tell you. And we're
Yeah, I
really
mean,
proud of you.
thank you. Yeah, there are, I mean, I won't say they're overly strict requirements because I think they're fair, but you have to be practicing a certain amount of time. You have to focus a certain amount of your practice on this area of law. And you actually do have to pass both a, kind of character and fitness test where the the bar examiners will reach out to other attorneys and make sure you actually know your stuff. And you also have to pass an exam, which is kind of like taking another bar exam, but specific to this area of law. So it's a lot, but I think it's worthwhile. And now I'm on the committee that puts together the class that teaches how to pass the exam.
Well, we'll be going to your schedule for, I guess, the last few days in September and then going into October and November, right
Sure.
before first break. But let's get to the questions. And I was just
Let's
telling
do it.
Al, we got more questions this time than ever before, and we so appreciate them. The only thing I ask that not everybody remembers it, let us know if you're a condo or an HOA. It really does help. So let's get started. We're going to start with
All right.
Jerry in Winter Park, who is a condo. He wants to
Okay.
know, is visitors with ES dog required to advise the association or property management in advance of arriving with the dog? The tenant's lease does not allow pets or dogs.
So we're talking really two different issues here. One is whether and ES, I'm presuming they mean emotional support animal.
Yes.
So you're supposed to notify in advance of violating association rules. Now, here's the interesting thing. I think that the question included a statement that the pets aren't allowed pursuant to the lease. The lease has nothing to do with association governance. So that's an issue between the landlord and the tenants. That has nothing to do with the association, unless the governing documents of the association actually establish pet-related rules. So the association takes zero action unless it has covenants or rules that say you can't have pets in the community. Now, as to kind of registering in advance or at least notifying the association, hey, this is my support animal. I'm going to be bringing them into the community, etc. Yes, people are supposed to notify in advance, but the reality is it almost never happens. And I wouldn't treat the fact that the person didn't choose to notify the association in advance. I wouldn't treat that as something where you come in and say, you got to get that dog out of here immediately. What you would generally do is say, we've got a no pet restriction. You need to, remove the dog. And once someone says, this is my emotional support animal, technically, unless it's an obvious condition and an obvious function that the animal serves, there's a procedure you can go through. We actually did fairly frequently a fair housing class that's available for free on our website. So if you go to kbrlegal.com under the resources tab, I would just recommend that anyone that has questions like this, go ahead and watch that class, and you'll get maybe not more clear answers, but you'll at least get the breakdown of how this is all supposed to work.
Okay.
I mean, it is a violation unless and until it's proven that this is actually a qualified emotional support animal.
Shirley in Sanford, she wants to talk about opening an online account with the DBPR. Do you have to create and maintain an online account in an electric format? What information will they require?
So there is information that is listed in the Florida statutes. That's what they're supposed to be asking for. You can register on DBPR's website for what we're talking about here, that registration. Now, keep in mind, I don't believe that HOAs are required to do this. It's condo only. It may be co-op. I don't recall offhand whether that statute was also changed when July 1st hit and these requirements came about. This needs to be done, this registration, by October 1st, according to the Florida statutes. The problem is DBPR included a whole bunch of stuff on their website that, according to the statutes, you don't need to fill out. But I don't know if they'll allow you to have a, click through and complete the form unless you fill out everything that they're asking for. So they're kind of putting everyone in a position where it's not clear whether you'll be allowed or able to comply without filling out everything they ask for. And frankly, if that's the way that they go about doing it, the best advice I can give, although it's not legal advice to any particular association, is listen, you can either comply or not. And then you can argue the reason you chose not to comply. Which risk does your board want to take is really the question that needs to be answered. My perspective is it's probably safer to include the information. None of it is really, overexerting or requiring you to do a bunch of research. It's information about the community is really all they're asking for.
Okay, we're going to go to Hillary in Orlando. Does the bylaw supersede a rule book in a condominium association? Also, does the county supersede their permits that issued by a park condominium?
So the bylaws will supersede rules made by the board. The order of operation of your governing documents is essentially declaration, which is some people call it the CC&Rs in a condo. It's a declaration of condominium. Then your articles of incorporation, then your bylaws, and your rules come last. So in the event of a conflict, you go bottom up. If the rules conflict with any of those documents, that rule is not valid. Okay. Now, when it comes to a local ordinance or a city or county rule, it depends whether there's actually even a conflict there as to whether or not that county rule will supersede. When it comes to what's required to issue a permit, that's going to be a county issue. It's not going to be an association issue. But there could be a distinction, and this is why I say check and see whether there's a real conflict or not. There could be a distinction between what's required to get a permit and what the association is allowed to require regardless of what's required to get a permit. So the association can be more protective of its common elements, of its units, than the city or the county are of the public in general. So you need to make sure when you're asking the question, is there even a conflict, or is it just that there are two separate requirements that the owners need to comply with in order to do what they're trying to do?
Okay. This Jerry in Longwood, I don't know if you get many questions like this. They want to know is what if the new board comes in and doesn't understand the assessments, but the past board isn't helping them? What can they do?
Well, if the past board isn't helping, and that includes
somebody just walked away.
Yeah, I mean, that happens frequently. People just get tired of being beaten down as volunteer directors, and they decide, you know what, enough is enough. At that time, hopefully they've turned over, and if it's a condo, they have an obligation to turn over all of the association records to the new board. You can do an audit to figure out what the hell the previous board did, or you can go through and review the records that they give you. Now, if they don't give you those records, you might have to try and reconstruct them. The alternative is you figure out what you're actually spending based on the contracts you have, based on the expenses you have and the amount of people who are not paying on time or not paying at all. And you can amend the budget mid-year with the excuse essentially being, listen, we have no idea where these assessment amounts came from. Now, alternatively, as long as the assessment amount is actually enough to cover the bills that are coming in each month and you're actually getting those bills and paying them, you can just wait until next year, figure out what the bills were for this year, and adjust your budget accordingly so that it's appropriate. Because keep in mind, I know the question was about the assessments and not understanding where they come from, but in reality, they come from the budget. It's just taking the budget and splitting it by the proportionate share of each lot or unit in the community. So if your budget doesn't make sense, if your assessments don't make sense, look at your budget to figure out what they should be. If your budget doesn't make sense, fix it. That's unfortunately the best guidance I can give. And, there are some instances where the association has to actually go back and send a demand or even sue the former directors to get the records back to be able to perform the business of the association. whether that's necessary or even, advisable or not, I'd run it by your attorney. And if you don't have one, you probably should be looking for one in the near future, because any community that doesn't have an attorney is probably doing something wrong because they're not asking for legal advice on legal matters.
We got a couple of people who wrote in. Do you just represent the associations only?
I'd say 99.9% of the time, yes. It's extremely rare that our firm takes on, we don't take on any other cases. We don't do personal injury or anything like that unless it's defending our association clients. But when it comes to, I presume the question is, do you represent individual unit owners? And the answer to that one is very rarely. Yeah, I mean, it's rare, and it's usually only going to be when dealing with an election dispute or a recall. And even those, I've kind of frankly decided that my office doesn't really work on them. The primary reason being we want to focus on representing the associations, which is really what our firm does. There are a lot of attorneys out there, both, South Florida and Central Florida and otherwise, who do a really good job of representing individuals. And frankly, I'd be more comfortable giving that person that knows what they're doing and routinely represents owners a referral and saying, hey, you know what, this is someone that does this all the time versus, okay, we can take the other side of this occasionally. That just, if we're going to focus on one area of law, I would just assume focus on, one area of law, but one side of it. It's kind of like when you've got a prosecutor that suddenly decides, I'm going to jump to the other side, and kind of has to learn how to operate on that side of the case. I would personally rather know, everything that I'm doing, and very rarely have to look up things that are statutory or case law to try and get the answers and things like that. So the answer in a lot less words is very rare. Do we represent anyone else?
We're going to go to one of our listeners, Paul. He wants to know, it is my understanding that condo owner names and addresses may be requested and distributed to owners, but telephone numbers and email addresses are prohibited.
In some instances, yes. Now, that email address that was designated for use by the association to provide electronic notices. So, when you're getting your notice of meetings by email, that email address is actually an official record that's subject to disclosure. The phone number, that's one that the owners can ask to keep out of the records. And when it comes to the name of the owner, unless they have some kind of statutory exception, sometimes, for example, it'll be a police officer, a judge, someone like that has a statutory exemption from that information being made public by anyone. That might be redacted, but the property address for certain is subject to inspection. Any mailing address is also subject to inspection. So kind of right, but there are a couple exceptions to what you're saying.
So here's a follow-up from him. Can you tell us the procedure for obtaining permission for each distribution?
Well, you have that authorization based on the statute. So it's just a matter of, if someone has that exemption when they're providing the information, and when I say the exemption, what I mean is the sharing their name, sharing who the owners of a unit or a lot are, that exemption should be disclosed to the association right when they're saying, hey, I'm buying this property. And it generally doesn't go away. So, the reality is it's not a procedure for when you can disclose it. You disclose it when there's a records inspection request received by the association. And if there's a policy in writing governing those records inspection requests that the board has adopted, you follow that policy as well. So, for example, in an HOA, the statute says you need to submit that request by certified mail return receipt requested. If it's sent by email, you don't necessarily need to respond. But my point is, you follow that policy. It's not a procedure of what is needed to disclose. It's a procedure of what's needed to hold that information back if you're even allowed.
One of our listeners is in an association in Cocoa Beach. He's the treasurer. and he wants to know, can you tell us about new items in HB 913 where board members may be criminally liable?
Yeah, that's in our condo board. Condo board class and condo cam class. That's the legal update for 2026. That's an hour-long class, and about 15-20 minutes of it is taken with this particular topic. So I would suggest just going ahead and going on our website. I think we've got 1 or 2 of those classes already scheduled, and just I would watch that class, even if it's after it's recorded, to get the information, because it would take a bunch of time for us to go through those either new criminal acts that have been added to the statute or the ones that have been changed so that they are a different level of criminal action.
We're going to go to our first break, but first, Alan, give everybody the schedule for your classes coming up, since we're talking about classes.
Sure. Well, I've got a webinar on the 29th of this month with Jeff Rembaum, my partner. It's our association matters, which we do about once a quarter, and it's about neighbor-to-neighbor disputes. We've then got on the 30th HOA certification for board members. That's with Peter Mullengarten in our Palm Beach Gardens office. October 3rd, an HOA financial literacy course with Kirsten Henze from our Tampa office. October 8th, cable and internet agreements. So those bulk agreements that you might enter into with Hotwire and a couple of the other companies out there. That's another one with Kirsten Henze from Tampa. October 14th, I'll be teaching guest restrictions with Chuck Nash in my office in Winter Springs. And then November 12th is the Orlando Condo and HOA Expo. I'll be teaching 2 classes there. Chuck Nix will also be there with me, and possibly Anthony Grevy of my office will be joining us because I'll be out for probably 3 hours out of that time teaching classes. So that's what we've got coming up. But watch the website, because those are the classes that we've got now. It's not even October yet, and we're talking about 3 or 4 classes in October, November. We'll probably up that to about 9 or 10 by the time this month is done and we get started with these classes actually being taught.
Where's the expo held at, Alan?
It is at the Orange County Convention Center. So that one is a 2 times per year event, and we usually end up speaking, and we'll have a table there. So if you'd like to come by in person, just make sure it's not while I'm in one of my classes, or feel free to attend the classes. It's free.
Okay, we're going to go to break. Tell people how they can, the best way to reach, because you've got offices in Orlando and Tampa and West Palm Beach, and also in Broward at your main office in Pompano. Is there a number they can call that's good for any location?
Yeah, fortunately, other than the direct dials for each person, the 954-928-0680 number will reach the Pompano office, and they'll direct you to whoever you need. It'll just be, you can call that number and reach anyone in any of our offices. The easiest way to reach me, because I'm on the road occasionally, is via email, and my partner Jeff Rembaum made that very easy. It's as@kbrlegal.com.
We're going to go to break. When we come back, we've got more with board certified attorney Alan Swartzide. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. We are here with board certified attorney Alan Swartzide of the K. Bender Rimbaum Community Association lawyers throughout the state of Florida. This is the last Thursday of the month. We appreciate your questions. Alan, I got a question here that I hope you understand.
Okay, no
And
problem.
I apologize. I hope I wrote it down right, but this is from Brad and Sanford. HB 913 again states that even employees of business that the association does business with is a conflict, but if the board approves the relationship, is it okay?
So I'm going to just go through the procedure for when there might be a conflict, because the board can approve the contract that has a conflict involved. But all right, I'm just going to go through the conflict procedure because it's a little bit difficult to interpret what is actually being said here. So when there is a conflict of interest, and that happens whenever there is someone who is involved in the transaction and someone who is on the board that has either a familial relationship or a financial interest in the transaction. So if that board member has someone within, we call it the third degree of consanguinity, and it's basically your blood relationship up to grandparents, down to grandkids, across and over to, I think, uncles and aunts, possibly only brothers and sisters. But if there's that blood relationship with the person that's actually going to do the work or is contracting with the association, that director needs to disclose to the board that there is that conflict. 2/3 of the remaining directors, not including this individual, need to vote in favor of the contract. And if that is not disclosed, or the person does not abstain from voting on that particular contract, the contract can be canceled by the members. So essentially, if you've got a conflict, you need to disclose it. 2/3 of the remaining directors need to vote in favor of the contract, and you need to abstain from parts of the discussion. You can present it, and then you got to disappear while the discussion and voting is going on. And that's because the legislature wisely doesn't want this person who has an influential role in the association to influence the decision in their own favor. You can present, you can advocate for it, but then when the actual board discussion is going on, you walk out of the room. When the vote's going on, you stay out of the room. So I hope that kind of answered the question. Unfortunately, I'm not really understanding the situation about what the relationship with the business might be. So hopefully that helps. If not, feel free to shoot me an email. Maybe we can help.
Robert in Orlando, and this is a good question since we're in the middle of hurricane season. He says, does the board have the right regarding hurricane windows? If I find one a lot less expensive, can the board make me buy the more expensive hurricane windows they suggest?
They can, if they're being a little bit, frankly, difficult. What I've been advising communities to do when the board is actually putting these hurricane specs together, which have been required since over a year ago, according to Florida law. But now that they're finally getting around to doing it a year later, I'm telling them, listen, make it so that you need to meet certain specifications, not that you need to buy a certain brand, model, etc. If you meet the specifications, you meet the colors, just like using paint on a building, it should work the same way. As long as you're not impacting the overall appearance of the community and you're not using something that's substandard, it shouldn't make a difference whether it's the exact same model or the exact same installer. That said, there's nothing in the statute that specifies that the association can't include specific models that you're required to use. So I don't think it's a great idea unless you really want to be overly controlling, but some communities, the board does. So that really comes down to your individual board and whether they're willing to accommodate different pricing models and stay with the same look and the same effectiveness, or if they really want to control the specific model that gets installed in everyone's windows. Now, the thing to keep in mind from my perspective, if you are the person on the board making this decision, those models change year to year. So you're going to have to update your architectural standards or your hurricane standards once a year or so if you're not allowing for a little bit of leeway. So frankly, all you're doing is making your life more difficult as a director and making the members' lives more difficult in having to use this particular model.
Cocoa Beach has a new ordinance permitting a maximum of 8 guests for short-term rentals.
Okay.
Can an owner here hire private security to enforce this limit for a problem renter?
So it depends whether we're saying that it's the owner of the unit where the problem renter lives or just some other random owner. I mean, anyone can report a violation of this ordinance to the city. So if that's what you're asking about enforcement, yeah, I mean, when you have an ordinance that's being violated, you generally don't take care of that by a court proceeding. You report it to the city takes care of it for you. And if that also violates a rule of the association, then yeah, and any owner technically might be allowed to enforce that rule. I don't know that you'd have standing other than under the declaration and the statutes that say the covenants and the documents can be enforced by any owner against any other lot or any other unit. But chances are, my recommendation to an association that I represent would be to first see if the city or county will take care of it for you. If they've got an ordinance, it's their responsibility to take care of the issue, and it's at no cost to the association or the complaining owner. That's usually going to be better. I mean, I know it sounds counterintuitive for a lawyer to say, hey, spend less money in attorney's fees, but that's really the way that I try to look at those types of situations so that the association has the money to go out and do more important projects rather than just dealing with problem children, so to speak.
Okay, Reed in Orlando, will non-board owners be able to look at the information at the DBPR site?
You know, that's a good question, and I candidly don't know the answer. I mean, you could probably send a FOIA request to DBPR for a copy of what was filed. I don't remember offhand whether any part of the statute says that that's not subject to a FOIA request. I honestly don't know. So that's one of those that I'll probably be looking into shortly, but I don't really know offhand.
Okay.
I know that's weird
Riley
for an
in
attorney,
Orlando,
especially me, to
this is an
acknowledge.
HOA. I'm sorry, we get so many people wondering about a conflict of interest, Alan. This one is, can a board member who's a president also work for the property management company? I feel like this is a conflict of interest.
Well, I mean, it's a conflict, yes, but it just depends how that conflict is addressed. If someone is the president of an association and it is also the manager of the association, I've had this come up in the past, and my opinion was, yeah, it's a conflict. You might be able to disclose it and, go through the conflict resolution process that I mentioned earlier to address the conflict of interest. But my concern would still be that there are different obligations for that person as a manager versus as a director and as the president of the association. Now, hopefully those never actually contradict each other, but if that were to ever happen, this person would be in, a hellscape legally, where there's really no right answer other than to resign one of those positions. So I would say it's not advisable, but it's not expressly prohibited.
Well, I'm putting this one up. This is a long question, but they have written us for the last 4 months. So I just said, I'm going to put it on there. This is from Nate in Orlando.
Okay.
Plus, he said he really enjoys your show. So,
well, then I don't trust them.
So here's the question. It's always that your show is always informative, but can a unit owner that has restricted occupancy per the bylaws in his unit ask another unit owner to register his parents so the family member can live in the association. This unit owner is trying to circumvent cause he already is in violation of our occupancy. What if the board doesn't have a violation committee? It's difficult for people to establish in my association. That's a
Well, that's
mouthful.
yeah, that again, that's kind of two questions. So I'll answer the last one first. Having a violation committee or a fining committee is only required in order to fine people, to suspend use rights for a violation, or to suspend voting rights for a violation. If you're going to use any other enforcement mechanism, you don't have to have that committee. So if you're just going to seek an injunction to force this person to actually do what they were supposed to do, I couldn't care less whether you got a fining committee. Your board has the authority to pursue those violations. Your manager, if you've got one, is normally the person that'll send the violation notices and be able to move forward. So whether you've got a fining committee or whatever other committee you want to call the same type of committee, the fact that you can't embody that committee, frankly, I don't care, because I think that a fining is kind of a complete waste of time, as I've discussed probably 20 times on the show with you, Steve. Fining doesn't get the job done. It just tells people you did wrong. And for a lot of people, it's just like a fine that the city levies. I mean, this is the cost of being allowed to violate the covenants, because you're not forcing them to fix the problem by fining them. You're just telling them they did wrong and that they owe you some money. So I would use a different enforcement mechanism. That way the fining committee isn't even necessary. Now, if you want to suspend use rights and suspend voting rights, yeah, you would need to have that committee if the violation is the reason that you're suspending. If it's for non-payment, you don't even need that committee. Now, back to the question of what do we do? Well, the question then that I would return with is, does this person own more than one unit, or are they just trying to use someone else's occupancy to let their parents live there? If they own more than one unit, they're probably going to be able to get away with it. If they falsified the application and they really have, 5 people living in one unit and one person living in another, but they said that there would be 3 in one and 3 in the other, or I'm not trying to do the math correctly here, but you know what I mean.
Yes.
If they're falsifying the information, then that application is false, and that in and of itself, I would consider a violation. So, if and hopefully your application package says that falsifying this information will invalidate the approval if given. Because that should be in every one of these packages. If you lie, and that's why we said okay, sorry, but you don't get to get away with it just because we said okay and you tricked us. Doesn't work that way. But even if that package doesn't say you're not allowed to lie, there may be ways around it. But frankly, that would be one that I would run by the association attorney. And again, it sounds like you're not really getting a ton of legal advice here. That is what you really need. You need legal advice as to what the options are based on your particular set of governing documents.
Cindy in Orlando wants to, is it true the board must take a vote on each fine before it's imposed on a resident?
So kind of yes, but in reality, there's a way around that. The board needs to vote on fines, but they can vote on one giant list of, hey, all of these violations that we've reviewed, we're going to levy fines against all these people. That can be done all at once in one motion, one vote. That still needs to go to a fining committee in order to fine anyone. But it's yes, the individuals need to be placed on notice that there's a fine. But it can be, we're voting on these 15 different lots whose violations have been ongoing for X amount of time. It doesn't have to be a one, we're going to vote for this one, then we're going to vote for this one. It can be just in a batch.
Go to Brad in Orlando. He wants to know I've never heard anyone ever ask this. He wants to know if it's legal to turn the Zoom off during good and welfare. Can you do that? Each unit has the right to speak on the agenda, don't they? I've never heard of good and welfare.
Yeah, I mean that's something like a fraternity would do.
Yeah.
Sometimes, it's like parliamentary procedure more than anything that really doesn't belong, in my opinion, in an association meeting. If it's not on the agenda, then no, those individuals don't necessarily have the right to speak at that time. If it's on the agenda, then yeah, I mean, every member of the community has the right to have their 3 minutes if they choose to use it, subject to reasonable restrictions by the board. So, if that item, that good and welfare, is on the agenda, then yes, everyone should have the right to speak. If it's just something that the members choose to do at the end of the meeting after the meeting has been closed out, no one has the inherent statutory right to speak during that time. So it really just depends on how the meeting is conducted.
Kelly in Orlando is an HOA. This is about auditing. She wants to know, she said, we have not done an audit for 5 years. Any suggestions?
Well, I mean, if you haven't done one and you want one, you can ask the board to do it. If you're on the board, you can bring it up at a board meeting. If not, you can send it to the board. But keep in mind, it sounds like you're trying to imply that it's required, and that's not required for an HOA unless you have at least $500,000 in revenue every year, actually more than 500,000, or you have 1,000 lots or more in your community. So it may be that you're not getting an audit done because you're not legally required to have one done. Now, if you are required to have it, yeah, that should be done every year unless the members actually voted not to do it. So it may be something that you actually demand the association do if that's not being done when it's supposed to.
Lori in Orlando, this is a clarification. It's regard the new Florida statute about Zooming a meeting held. Is the physical location still needed?
So if you're holding a meeting via Zoom, yes, the physical location should be used. You really have kind of needed a hybrid meeting since the state of emergency was declared over for COVID. But in reality, yes, this is still something that you should be holding meetings via hybrid unless your bylaws explicitly say you're not going to do it. You would need to provide access to anyone that isn't able to attend on Zoom, even if your bylaws say you can hold it only virtually.
Craig in Orlando, thank you for bringing the show to us. I have watched for the last 6 months. I've turned so many people on to this show. How many support animals are allowed in one unit?
As many as you can get a reasonably reliable physician's note saying you need is the only answer I've got. And now keep in mind, if you've got literally the crazy cat lady who is legitimately certified as having a disability. When I say crazy, I take that a little bit more lightly than it should. But I mean, if someone has a disability that's been diagnosed by a physician that's qualified to make that diagnosis, it may be that she needs 15 different cats in her unit. Okay, now those 15 cats still need to be maintained cleanly. The unit needs to be clean. It's not that you get to have as many animals as you need and you don't have to take care of anything. If it starts to impact other people, you can still enforce the violation separate and apart from the amount of animals or having the animals. But there's no number limit to how many you can have in the Florida laws or in the federal laws governing fair housing issues.
Okay, here's another one of those questions that I don't quite understand. It's from Lois in Orlando. It's regarding the new DBPR requirements. Does the same requirements apply to HOAs as condos? That's her first question. We are a separate HOA for amenities and common property for two separate condo buildings.
So it'll generally apply only to the condos, the two condos, probably not the HOA, because this was something that I don't think DBPR has the authority to require that registration. I'm pretty sure it's condo and co-op only.
Okay. Neil in Orlando, never miss one of your shows. What is the difference between a structural inspection and a 40-year inspection?
There might not be any. It just depends what your particular county or city is actually going to require. A structural inspection depends which one of the two that we talk about almost every show that you're talking about. Is it a structural integrity reserve study or is it a milestone inspection? Those are two different things. Structural integrity reserve study pertains to an inspection that's being made for the purpose of figuring out what you need to reserve every year and on an ongoing basis. A milestone inspection is checking to see if your building is structurally safe. That's more common and more comparable, in my opinion, in most instances, to what some counties and cities are requiring you to do with respect to a 40-year recertification. So that 40-year is really just going to be an inspection of the buildings to make sure that everything is structurally sound. A milestone inspection is going to be similar. Honestly, I can't tell you without knowing what the requirements are for your local jurisdiction for that 40-year, whether it's comparable to a milestone inspection. If it is, and it covers everything that's in the milestone inspection, you might not need to do both, but I would run that by your attorney, because if it covers everything the milestone inspection requires, technically the law allows you to use that one inspection for both purposes rather than having to go out and get two separate investigations and inspections.
Robert and Kissimmee, will your firm be doing a budget seminar along with your certification seminar?
So I honestly have not done the class that Kirsten's teaching that I mentioned, but I believe the financial class that I mentioned earlier is probably going to cover some budgeting. It's financial literacy, and I anticipate it's going to be budgets as well as some of those financial reports. That one's on October 3rd. So, I would suggest signing up for that. All of the classes that I mentioned are free. They're going to be held via Zoom. They're easy to attend, presuming that you're not at work at the time. And so I would check that class out if that's what you're looking for.
Okay, this will probably be our last question. Sherry in Orlando wants to know, can one condo owner block the developer?
Are we saying physically block them? It depends how big the owner is, but I don't know what you mean by blocking the developer. Is that blocking
Doesn't the developer take over? I mean, gives over to the association after so much time?
That's not an owner blocking them. The developer might be trying to block that turnover that you're talking about, which occurs when certain events happen. It's 50% of the HOA has been sold out. 90% of the HOA has been sold out. It's that turnover that the developer might not want to give up a little bit of control over the board. But I'm not really sure what an owner blocking the developer would actually mean. So maybe we can either go to a different question and do that one as the last one, or if that's all the time we've got, you do what you got to do, Steve.
Yeah, I got, you never, all these questions here, I never know, because you are so good at answering them. I never know how long the answer is going to be, but I'm going to tell you something. This shows how good you are. We've got 3 more pages, which we'll get to next month, of questions. This show has grown so much, Alan. Listen, I got to tell you, people appreciate you so much. I know how busy you are, and you give up your hour to come on such a busy day. People, they just, there's so many people who thank you for doing this. You'll be back again with us next month. Give people again the phone number, how they can reach K. Bender Rimbaum.
Sure, 954-928-0680.
Bro, you're the best. We'll see you next month.
Thanks, Steve. And thank you to everyone who listened and who watches later on our website and everywhere else that this will be posted.
Thank you. That's going to do it for us today. We'll be back in with you next week with more Ask the Experts. Thank you, Juan.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk 4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.